Well, welcome back, everyone. Welcome back to the signing series video. I'm Jeff Belomo, and I'm excited to do this one. This is actually the big one. So, this is going to be the Asset Protection Trust, as we call it, just to give us a little bit of kind of reminder of where we are and what's going on currently. At the Blueprint meeting, we did a little bit of education, and then we completed our workbooks. And based upon the information provided in the workbook, we went ahead and drafted documents for you. You should have them in front of you. You are in the middle of the signing series video, which if it were me, I'd probably do this one last, just because I like to get the other stuff out of the way, the easier stuff. The advantage of the videos is that you can watch them back as many times as you want. One of the things that we heard clients saying was that having not seen the documents in our old system and then just walking through them in a meeting and signing was, disconcerting to some. We did it for 20 years and it certainly worked well, but we're trying something new in regards to this portion where we want you to have them. We want you to go through them in detail. And these videos allow us to kind of really dig in way more detail than we would have ever done before. Most of the signing meetings were about 40 minutes, and these videos all told are probably going to be around 2.5 or so hours. So way more information, and also the ability to watch back as often as you want. So this is the Asset Protection Trust. So if you think about what we're doing here, is this is the document that is setting up the wagon for the Asset Protection Trust. I'll point out the portions in the document that kind of are the magic as far as how do we get the asset protection. We've already gone over the financial power, the medical power, the deed, the affidavits, the revocable trust. And now we are talking specifically about the Asset Protection Trust. If you recall, the will and the revocable trust all are pouring over into this trust. The reason that I want to do that is we are very hopeful that there won't be anything in your name alone, right? That's kind of the goal. We want anything that you have to either be into the revocable trust or the irrevocable trust. Those are the two places that we want everything to be, so that it all ultimately ends up in the Asset Protection Trust, which is going to be setting up the separate share trust, the special needs trust, and those things for the children, Dan, Jeff, and Reese. Which obviously your case will be your specific facts, but this document is going to be those three individuals. So with everything pouring over into this becomes the most important document, specifically in regards to the asset protection language, but also the separate share trusts and the special needs trust for the children later. And we'll also pay close attention to control, right? When do the children, Dan and Reese specifically, get control of their assets, which we did different ages because they are different scenarios as far as their aptitude and their ability to manage money. And then Jeff specifically will be in a special needs trust because of his disabilities, and he will never obtain the right to fire. A special needs trust says that they can't have that ability because that would give them control, which would mean that the assets would be countable resources for government benefits. So what I tried to do in drafting this and also in writing the book was to provide 3 different scenarios as far as, one in a special needs trust, one where we're giving control immediately, and one where they don't earn control until much later in life, because obviously every kid is different. These are conversations that we had in the Blueprint meeting, and ultimately you decided on the age. So those are the things that I would pay attention to. Also, remember, we're relying on you for spellings. We're relying on you for making sure that the right names, are in the place where it says who gets it, when they get it, how they get it, which I'll explain today. That's really the part that I need you to focus on. So that way, when you do the one-to-one attorney review meeting, you can focus on, okay, there are these mistakes or these errors in handwriting. That is the one thing that we're interested in seeing how it plays out, is the handwriting is now client dependent, which previously it was team member dependent. And usually, most of the time, if I wrote something, if somebody brought it to me, I could tell them what it says. Whereas now the drafter and the reviewer are relying on the handwriting of our team. Of our clients. And that obviously is a thing outside of our control, as far as there very well could be mistakes in spelling. And that's why I like that you're getting them ahead. I like that you're watching these videos. I like that you can digest them and take them in your terms before you end up signing. So that's a great kind of twist to this new process that I think is going to be a great addition. Without further ado, I am going to bring up the Smith Family Trust. And as I said on the Revocable Trust video and the affidavit video, your document will simply provide the Smith Family Trust. We added Irrevocable here just so that you guys kind of knew which trust we were talking about. But internally, we always refer to it as the Family Trust. We know internally that Family Trust means Irrevocable Asset Protection Trust. And we know that the Smith Revocable Trust is a revocable trust. The reason that we don't add irrevocable to general trusts is because banks, financial institutions wig out over the word irrevocable. And if you go back to our original training in the 3 secrets, and depending on the blueprint, may be mentioned there as well, what most of us know about trusts, we know about tax trusts from the late 90s. Tax trusts in the late 90s were used for people who had more than $600,000. Currently, the federal estate tax exemption is $12.92 million. And if you're married, it's another $12.92 million. So let's call it $26 million, right? Just for argument's sake and for the conversation. But tax trust, you're not allowed to be the grantor and the trustee. You're not allowed to have control. The reason for that is because that's what gives you the ability to get that money above 1.2 million or 600,000 back in the 90s to not be included in your estate for tax purposes. Well, as you remember, our definition of estate planning is control, control, control. I want to control my property while I'm alive and well. Plan for me and my loved one if I become disabled. Control is the key. Well, in a tax trust, if you have more than 26 million or 12.92 million, if you're a single, you cannot have control. Well, because the bank and financial institutions hear the word irrevocable and only think of tax trusts, it just causes questions. It just makes them not understand it. And so we have, for the last 20 years, we just use family trust. We know internally what that means. And then the document itself will set forth the terms. Most institutions don't necessarily even pay attention. Once they just see it's a family trust, they don't think anything of it. And it goes through a lot easier. One comment that I want to make, just because we had it come up yesterday, and while I'm doing this video, I'm thinking of it. We did have a client come in and was wondering if he should provide the full document of the trust to his financial institution. And for whatever reason, he thinks he heard me say that I said absolutely not. And that is not the case. Honestly, those affidavits, as I said in the affidavit video, were a creation of lawyers hoping that we wouldn't have to have you carry around the full trust, hoping that it would be enough for them. And it certainly provides the information that they need. The main reason why I continue to do them is because 95% of the questions that you're going to ask are on those affidavits. And so rather than, provide the whole document, dig through this whole document, it is easier just to have the affidavit, which is a 1-page, 1.5-page overview of everything that we've done, what type of trust, who's the trustees, et cetera, more for convenience purposes. But the truth is, when you're setting up these accounts, most of the financial institutions and banks are going to want to see the full trust. No reason to hide it, no reason not to. You can certainly push back and ask why they can't accept the affidavit, but truth be told, at the end of the day, they do not have to open the account if they don't get to see the full trust. We will certainly try to educate them. We'll try to use the affidavit, but at the end of the day, just have the trust ready. There's nothing in it that is so personal that you're divulging anything or disclosing anything that they should or shouldn't know or not know. So just as a way of background please just give it to them if they ask for it. No reason to hide it or no reason not to give it. So as you can see, we are looking at the Smith Family Trust, dated the date that you're going to sign it, created by Belomo and Associates, and then of course our table of contents. As I've said in other videos, table of contents, like any good book, you need a good table of contents. So here's your table of contents for your good book called Your Trust. Again, start here. Do not just start digging into the document. Breathe, take a minute. You will see here that it's broken down very kind of systematically. Background information, lifetime, after death, then residuary, then in case we have anybody who may be inheriting who was not provided for a trust, which really would not be the case, but we leave it in here. We have understated age trust. We have special needs trust embedded in case anyone is disabled and receiving public benefits. We're going to provide for lineal descendants and the ultimate beneficiary paragraph at this point. If we provide for anyone other than lineal descendants, we're going to trigger a 2% transfer tax. As we said, you still have control. You still have a power of appointment, which allows you to make changes to who gets it, when they get it, how they get it. The only thing you're giving up the right to do is give it directly back to yourself, right? So we can change that stuff. So if you want to provide for a non-lineal descendant, such as a niece and nephew, a charity, we will make that change later. Typically, we recommend waiting 6 to 8 months before we make that change so that there is no transfer tax. Then we get into trustee information. Then we get into trust protector information. Remember, the trust protector is typically always the law firm. We don't have rights to change who gets it, when they get it, how they get it. It is the ability that if you become incapacitated or one of your children become incapacitated and they're not able to appoint a co-trustee or appoint someone to oversee or appoint someone to help them, we can do that for them. Or maybe there's two siblings who are in a major dispute and they just don't like each other. We would have the ability to appoint someone to step in. So the goal of trusts, just to kind of rehash why we're doing this, yes, it's asset protection. Yes, it's probate avoidance. But the other advantage is everything is settled at the conference room table in my office, not in a courtroom, not having siblings hire lawyers and then have to go and have a judge decide what happens. We want everything to be settled internally. The trust protector allows us to be able to assist with that and appoint. Now, you'll see the limitations on who can be appointed later, but I just wanted to highlight that here. What powers are we giving to you and to your spouse and or your children or whoever, family members, as the trustee, the backup trustees? Then we have retirement accounts. Retirement accounts have changed significantly since the Secure Act in 2019. I believe it was December 23rd around 3:30 in the morning. So we did have to make huge overhauls and changes to our documents. All of the maintenance family members, the Red Wagon Club members were able to come right in and get that stuff changed and move along, which was a great benefit to them. In your documents, obviously, you're going to get the most up-to-date language because it's constantly changing. The Secure Act came out. They issued regs. They issued another version. Then they issued 2.0, which was basically Secure Act kind of modified. So we're constantly changing the docs. We're constantly getting updates. We're constantly massaging the language. And of course, you'll get the most update to language here. And then as we get more updates in the Red Wagon Club, we will be notifying you. We'll be having conversations about it, and we will be getting you in order to be able to update those. All right, so we're in the document now. Parties. So of course, Mark and Sarah are creating it. They are the grantors. Mark and Sarah are controlling it. They are the trustees. All right, so I just want to highlight that so that you're seeing that. So they are in control and they created it. The purpose, asset protection, avoiding probate, making it easier for my family, protecting as much as I can from creditors. Essentially, you're still in control. So there is no completed gift. We don't want it to be. It's you. You're still in control. This will be taxed when you pass away. in Pennsylvania inheritance tax. But that's what we want, right? Remember, go back to the training. We want it to be included. 4.5% is nothing more than a nuisance tax. It's that pimple on your back. Remember, I want the step up in basis for your kids. I want them to avoid the capital gains tax. I don't want them paying 23.8% on gains, which houses and stock accounts are often highly appreciated. So this is intentional, and it's also on purpose, and it is exactly what we want it to be. I just wanted to highlight it, okay? And then, of course, there's language in here that's going to comply with the Secure Act, where you're going to see eligible designated beneficiary terms, which is a Secure Act term. The trust. How do we know if an asset is in the trust? We are going to look at the titling of the asset, okay? So if it says Mark and Sarah Smith, trustees of the Smith Family Trust, dated, that is the asset that is in the trust. If it simply says Mark and Sarah Smith, it is not in the trust. Now, we have not funded anything. We are not at funding. At most, at this point, we may have gotten the assets that you're thinking of putting in, and we are putting together funding charts, and there will be a separate funding video that you will receive and have access to after you sign the documents. So we will discuss all of that at that point in time. For now, we just want to discuss what is titled in the name of the trust. Any asset that has this titling, Mark and Sarah, trustees of the Smith Family Trust. To start, we have advised, start with your house, start with the cabin in the woods, start with the beach property, and start with a small amount of money that you are not going to need on a regular basis. In order to kind of get comfortable with the mechanisms, the way it works, we recommend starting small. You can always build and add. Yes, there is a 5-year look back period if you add later. So if you're not in great health and 5 years is an issue, certainly we want to be a little more aggressive. If you're much younger and health is not a concern at this point, slow is always better. Remember what they said, and I think it was Aesop's fable, slow and steady wins the race, right? Isn't that what the turtle told the hare? So same thing with trust planning, all right? Life insurance, certainly an easy asset to put in. No reason not to. Let's get that cash value protected. And that's another simple one to do without really much thought. As we get more complicated, such as annuities and other assets, that's when we're going to want to evaluate each one independently and individually. Pretty much anything can go into the trust other than a retirement account. But we have found individual contracts that are prohibiting and causing some small issues. So we'll go slower with those assets. We'll be quick to put in the houses, the cabins, the life insurance, the beach properties. No reason not to. You can live in it. You can sell it. You can buy another one. All right. Putting the deed in here, the paragraph 1.04, it is going to be transfer tax exempt. Now, that is why we were so adamant in the blueprint meeting that we only name lineal descendants. To the extent that you don't have any lineal descendants, then we've already had the discussion in the blueprint meeting that there is going to be a 2% transfer tax when the deed gets filed. But this provision is saying we provided for only lineal descendants and it will be exempt from real estate taxation. That is our goal. That's what we want. And then we can always change it. You still retain a power of appointment, which we will see later in the document, that allows you to change it and give it to someone else. But to start, we would like to avoid the 2% transfer tax. Composition of trust. The trust is composed of any assets that have the titling Mark and Sarah Smith, trustees of the Smith Family Trust. So we can add later, right? You're allowed. Subsequent additions are allowed. But as to the new asset that gets placed, it starts a new 5-year look back period. The original assets are funded and the clock starts the day that they're put in. And then any additional start from the day that the new asset is put in. And there's a 5-year clock from that point on time. Gee, Jeff, what if we don't make it 5 years? We'll make it as far as we can until you need to go into a nursing home. And then we will reevaluate the situation. We will run the math. And we will definitely figure out what is best for your family from a mathematical perspective. The thing I tell clients all the time is that is the decision that is made 100% on data, statistics, and numbers. Nothing to do with emotions or feelings. It can't. It has to be based on data. The sooner we start the 5 years, the sooner we have the clock going, which provides the greatest chance of making it, but we can't control the rest of it. So we'll make a game time decision at that point, what to do if we haven't made it to 5 years. As I mentioned earlier, if your health is a little bit risky, definitely we'll want to be a little more aggressive of what we fund. If you're young and healthy and we're not expecting any of those issues, probably not a big deal. No new tax ID number. There's some regulations listed here. Part of the reason why we don't put the name irrevocable in the trust title is because they're going to require a separate tax ID number if we do, and that is not what the regulations say in the Internal Revenue Code. So if you have somebody arguing with you that it has to, please don't feel like you have to argue. Please refer to the guide and the DVD that you're going to get access to, which is called Don't Let Your Trust Trip You Up. And the guide is a wonderful guide that is going to really explain how these trusts work and really why you don't need a separate tax ID number. But I do have it in here. It's always better to point to a paragraph, a section, and not get into a discussion with the institution, right? There's no reason for that to happen. But here is the language that says that it does not need a separate tax ID number. It is in your social security number. We are still doing our taxes on our 1040s. So that is also section 1.08. And that is very clear there as well. Again, mostly for you to be able to refer people to. This is the paragraph that talks about reliance on the affidavit. It is in full force and effect. It is a replication or a summary, basically, of what the trust says in full, and banks and financial institutions are allowed to accept it and trust what it says and rely on it. As I mentioned earlier, if they demand to see the full trust, just give it to them. It really isn't worth arguing about. It's not worth fighting over. Just go ahead and give it to them. We're not hiding anything. There's nothing in there that is personal or anything that isn't anything that's okay to show. So third parties have a right to rely on what the trust affidavit says. So we can't show them the affidavit and then lie about it and then expect them to kind of be holding the bag. No, if they rely on it, they have a right to, and they fully can expect that it's correct, which of course it is. We would never do anything to mislead anyone. Scrivener errors. So essentially this paragraph just says, if my lawyer, Jeff, or the team is an idiot, please don't penalize me because of their stupidity. Please allow me to make the corrections, which we would have the authority and the right to do. That is a function that the trustee can authorize, as well as the trust protector. So we have fallback provisions in here to ensure that if there's any administrative changes that need to be made, we always have the right to do it. Of course, if you're married, it says we are husband and wife. If you are single, widow, or widowed, it will say I am single. And then I have children and their names are, or in this situation, we have 3 living children and their names are Dan, Jeff, and Reese. And then, of course, we just made up dates. Similar to the revocable trust, we're just talking here about the fact that what is about to come. The next section is going to be the lifetime trust provisions, then the residuary trust provisions, then the separate share trust provisions, and our beneficiaries. So why don't we just take a look at it and actually see what it says rather than talk about it in abstract. During lifetime, remember, how are we getting asset protection? We're getting asset protection because we're giving up the right to reach into the trust and give it directly back to ourselves. Exactly, right? Me or my spouse. If I'm single, I can't give it directly back to myself. For most of us, this section down here is going to read exactly as this one does, which is if I need money out of the trust, I can give it to Dan, Jeff, or Reese. Now, the probability is I'm never going to give it to Jeff because he does have a disability and he is receiving public benefits, which would disqualify him if we did this. So we won't do that. But what I will say is I typically just provide for it. This is a flexibility tool. This is not a restrictive tool, meaning just because he's listed doesn't mean I have to do anything. And you might have kids listed here that you have no intentions. You would not trust them. Remember in the 3 secrets in the blueprint, we talked about Larry, Mo, and Curly, right? Those were the kids. And we trusted Larry the most in the example. So we gave everything to Larry. Now, remember, if Larry doesn't do what we want, we have the right to remove him, change the terms of the document, and bye-bye, Larry. And Mo and Curly absolutely love you now, Larry, because you were an idiot. So this doesn't mean you're going to give to these people. This means that you can give to these people during life if you want to. It doesn't say you have to. It says if you want to. So we are typically more inclusive here than who we would probably ever distribute to if we needed to, but it doesn't hurt, right? And it also provides for descendants below the section that I have highlighted, which would allow for grandchildren and great-grandchildren, etc., to also receive. So that's a flexibility tool. For the very few minority of you who are relying on rental income from your rentals, this is where we may have a section that will say that you are named, but you are named only up to an amount of money that you have set forth. So we recommend what's the minimum amount that you need to live. The reason is because if we give access to you to income, the state has a right to argue that they have access to all of the income from the trust. Well, that can be an issue, right? Because let's say you have 2 or 3 rental properties and you've got stocks and they're spitting off a lot of dividends. And it ends up that the nursing home is going to take most of the income anyway. And that's not what we're doing. So we typically will limit it to a certain amount of money. That would be a conversation we had in the blueprint. And we would have talked about what's the minimum amount you need to live. That's what the nursing home would have access to. We prefer not to give any. So when you look here, you're probably not going to see your name listed. If you do see your name listed, hopefully there's a limit to the amount. If there is not, and we do want to talk about it in your one-to-one attorney review meeting, make sure you make a note that you want to discuss, that you want to put a limit on how much income so that they don't have access to all of it, which is my recommendation. And the attorney can talk to you in the one-to-one meeting. Now we're just talking about, to the extent that there are tax consequences that are coming, it is borne by the person whose social security number it is in, the grantor, right? And that's what we want. We want the person who's creating it to still take the tax consequences because they're doing it for, asset protection purposes, but they're still in control. So it's still them. This section here talks about access to principal. So you should not and will not see your name here, right? Now it's absolutely the 3 kids. Income, we may say a kid and limited the amount. This is where you will not see your name. We are giving up the direct access to principal. And in most our cases, we're giving up direct access to income as well. To the extent that we're leaving the income, we're going to limit it to a certain amount. Of course, the trust can pay expenses. This is where a lot of the magic is in the document. This is the power of appointment. The power of appointment, if you go back to 3 secrets and blueprint, is where Larry did not do what you wanted Larry to do. So now you can remove Larry from the document. You can change the terms of the document. This section talks about how you do that. Who can you do it to, right? There are great explanations here as to who we're allowed to do it to. Similar to the revocable trust, an advantage of these trusts is that you are in control. Yay! The problem is if you start to lose capacity and you think you're George Washington and you're giving away your money on the street corner, you are no longer acting in the best interest of the trust. Remember, the Uniform Trust Code and trust law says that a fiduciary, the trustee, owes a duty to the trust. Well, that's you, and you owe a duty to your trust. So if you're not acting in the best interest of the trust, we can't have you as the trustee anymore. So in most cases, we're naming the spouse and the children that, if they agree, can remove you as a trustee. And then whoever, if you're married, the spouse would be it. If you're not married or you're single, widow, or widowed, it would be probably one of your children or whoever you named would be stepping up, would be taking over. But this paragraph is where we get flexibility built in, that we can't have somebody not acting in the best interest of the trust. I think in 20 years, I've used this provision maybe 2 or 3 times. One was fairly recent. The mother absolutely has severe dementia. She is dating somebody in the nursing home and wants to give him everything, clearly not acting in the best interest of the trust. And we had to invoke this paragraph, but it's not often. We're talking very, very rarely. If you are married, of course, have it for both of you. If you're single, widower, then of course it would just be your provision there. In the real estate, we do have the right to live in it. We do have the right to sell it, to buy another, do whatever you want, right? And this is a section that provides for that. Earlier, we saw that it was real estate transfer tax exempt, assuming it's only going to lineal descendants. Here's where you have the right to use and enjoy the property, which is exactly what we want. Essentially, you're agreeing not to give the money directly back to yourself. And if somebody passes away, after both grantors pass away, we are going to administer the trust, which essentially is nothing more than paying the expenses, the claims, and the taxes. So I'll highlight this section. As with all of the documents, the headings are only merely to tell you what is about to come. It is not necessarily dispositive or providing the content, but this one does, right? This one tells you this section is about paying the taxes, the claims, the expenses. That is the whole point. I'm a lawyer, right? And the one thing that I've repeated over and over through these videos is the state and the Uniform Trust Code and everything that governs the laws is very specific, saying you have to be specific in providing for authority. None of this generality covering everything. No, that's not good enough. So in a section where all we are talking about is paying the claims, expenses, and taxes, it does go on for a long time. The part I want you to remember is this is a very insignificant portion of the document. You've already died. Your spouse has died. Now we're trying to get the money to our 3 kids, right? We need to get the money to Jeff, Dan, and Reese. How do we get the money to Jeff, Dan, and Reese? Well, before we can do that, we have to pay the taxes, the claims, the expenses. Okay, that's all this says. This whole section is saying nothing more than that. Now you get into how does it work, right? Coordination with executor. Remember, if you have assets in your name alone, you potentially are going to have to use your will. Your will named an executor. This allows the trustee to work with the executor. Now, the truth is, more likely than not, you name the same person. But just in case, we do want to give authority to be able to speak to them and talk to them and ask questions of them. So that's this section here. And again, just paying the taxes, the exemptions, how do we treat property? There is going to be language in here specific to retirement accounts. This is all of the Secure Act language. So to the extent that we're paying taxes, claims, and expenses, and it is a retirement account that we want to pay out of, how do we do it to get the best possible tax consequences? This section is going to go into ad nauseum. The stuff about September 30th is irrelevant. It doesn't matter. It's the law. It says that you have to pick a day and time, which they pick September 30th to make decisions by. After you pass away, your trustee comes in. We will guide him or her on making these decisions. This section is just saying pay the taxes, the claims, the expenses. How do we determine the amount? If we're using retirement accounts, how do we do it at the best possible tax consequences? The trustee has authority to make tax elections if they are going to be in the best interest of the trust. And of course, we will guide them with the help of your accountant and other professionals that you're working with. This is just instructions. Of course, the Red Wagon Club is thorough, lifetime, and complete. That is what we call our process of the Red Wagon Club. So it's just saying you're getting updates, you're staying on top of it, you're getting changes in the law. This is just instructions as to what to do and how to transfer assets. Make sure you get the tax returns filed and done quickly. The trustee has the right to get quotes, to talk to professionals, to make sure that it's being done properly. And of course, getting the probate done as well in a timely manner and making sure that everything is taken care of. Getting expenses taken care of, funeral expenses, other expenses like legal fees and other expenses that the trust may have. What are we doing with tangible property? How are we distributing them? How are we getting them to your spouse and to your children? Anything else in regards to those is listed here as well. And how do we distribute retirement accounts to Mark and Sarah? So if there are retirement accounts coming into here, this is called a spousal only retirement trust. We also discussed this on the Irrevocable trust video. This is so that we can name this trust as the beneficiary of the retirement account for Mark for the benefit of his wife, Sarah, and vice versa. We are naming the trust first and then them individually. The reason that we are doing that is because the law is changing constantly, and we need to be flexible at the time of death to make a game time decision. So we'll make that game time decision when you pass away and based upon what the laws are. We're going to evaluate the health of your spouse. Are they in a nursing home? Are they going to need a nursing home? Are the laws going haywire at that time? Do we want the money to go outright? The reason we do it that way is because as the trustee, your spouse can disclaim the interest in the spousal only retirement trust and have it pass on to them individually. If we don't name the spouse individually, we lose that flexibility tool. In a second marriage situation, maybe we don't want the flexibility, which would scare me, really, because what the law is changing right now, it's so hard to know exactly what they're going to do with it. But there may be reasons that we'll make a decision to do that. Currently, however, we're just going to move on to talk about the spousal only retirement trust. If you're a single widow or widower, this section will not be in your document because your asset, your retirement account, would not be going to a spouse. In this instance, this is just talking about that spousal only retirement trust, complying with the law, stretching out as long as we possibly can to the spouse, and keeping as much as we can protected for the spouse so that they don't lose it to creditors. All right. Residuary. So now both spouses have passed. We're giving everything to the 3 kids, a third, a third, a third. Currently, this section is going to go on to talk about retirement accounts. So here we go again. Secure Act, right out of the Internal Revenue Code. Literally sections that are just pasted out of the code because we know what language has to be in it in order to comply. I don't need you to focus on the language in these sections. These are the least important sections. The most important section is where it says your 3 kids, a third, a third, a third. That's what you focus on. The tax stuff we'll handle, and it is in here for you. Of course, we're talking about retirement accounts. What if they're minors? What is a conduit trust? Essentially, a conduit trust is nothing more than if income is required to be taken as, say, required minimum distributions, we're forcing that piece out of the trust. Okay. So for some reason, we don't know why, the government in the Secure Act has kind of gone after asset protection planning after death a little bit, saying if you're required to take an amount, like for a child, they have to take everything in 10 years. For a spouse, they can stretch it out over their life expectancy. But to the extent that we're doing that, the piece that is paying on the tax has to come out of the trust. That is a conduit trust. An accumulation trust is going to say, I can leave it in the trust to keep it asset protected. This is what the special needs trust provisions are saying. This is what is allowed under the new Secure Act. So that is one thing that they, for whatever reason, we're very generous about, which is great. I think it's wonderful that we're trying to help individuals with disabilities. They are allowing us to stretch it out over their life expectancy, and they're allowing us to keep it in the accumulation trust, which will keep it asset protected, not for spouses and not for regular, just ordinary children, as far as well-bodied who are not receiving benefits. If someone isn't not more than 10 years younger than you, this provision here is just explaining how to do that as well. Again, we're talking about conduit and accumulation. What if we're dealing with an individual with a disability? How do we stretch it out over their life expectancy? And then, of course, if there's any other beneficiaries of the separate share trust, it's a 10-year. What does that mean? How do we do it? Now we're getting into Dan's share. So Dan and Reese are going to read very similarly. If you do not have a family member with a disability, they also will read extremely similar to this, because only the special needs trust is going to be different in this section. Remember, our recommendation from the blueprint meeting is that everything goes in trust for everybody. You can give them control, but we don't want to give the money direct access to them because we don't want them to lose it. We want them to keep the asset protection from creditors, nursing homes, car accidents, etc. Divorces, for example. This section is the kind of similar for all of them. It's going to talk about getting a new EIN number. That is because after death, we're setting up a separate share trust. And then there are ways that we can handle the taxation part by K1ing income to the individual and having them pay at their individual rates. I'm getting in the weeds. Please don't worry about that. But this is just setting up the trust for them, for their benefit, keeping it asset protected. If Dan passes, it's going to his children per stirpes. This also is that lineal line so that we're not triggering a transfer tax. Now we have Jeff. He has a disability, and we're putting this into a supplemental needs trust, a third-party SNT. This is the part that is going to allow us to get access to the money for Jeff, but keep Jeff on government benefits. Okay, so this is the magic here. Again, this goes on forever. We can pay for anything for Jeff other than food and shelter. The premise is that government benefits will provide those, but to the extent that we want to pull money out and potentially lose benefits, the trustee does have discretion to do that. The purpose of this is to supplement Jeff's needs, not supplant them. Okay. We want him to rely on the government benefits, not on this money, if at all possible. The trustee has a right to consult with other professionals. Any and all taxes can be paid out of the trust for the benefit of Jeff. How do we distribute non-qualified assets to Jeff into the special needs trust? And we don't want him to be forced to take money out for any other support obligations. We want the money to be there for him to enhance his life. The trustee may review other eligible benefits that are possible for Jeff, such as SSI, such as Medicaid, and any other ones that could be available, and is allowed to distribute money, even though it could disqualify or reduce the benefit if the trustee believes that it's in the best interest of Jeff. We're not going to give Jeff money outright directly for things such as food and shelter, because we don't want to disqualify him unless a decision is made to do so. We aren't going to be able to be forced to pull money out of the trust by the court. We want to keep it protected as long as we can and continue to maintain his benefits. And if he dies, it goes to his children. This section for Reese is going to read the exact same as Dan. Now, there are some differences later, but right now we're getting the EIN, we're setting up the trust, and if he dies, it goes to his children. This is a section called understated age beneficiary that we could probably have removed from the document because we are providing for everything in trust for the kids, right? We want to protect it. That was our mantra when we did this planning. I always get nervous because, as you can see from these paragraphs, it says children per stirpes, children per stirpes, children per stirpes. But if the children and the grandchildren are gone and we have to find your closest living relative, I'm always nervous that they could say, yep, I get the money outright. That doesn't apply to me. I'm not a child. I don't have to have it protected. So this is a fallback that says, yes, you do. We're not giving you the money outright. You don't get control until you're 30. I don't want an 18-year-old being able to make that argument and access it. Trust me, they're not going to win the argument that it doesn't apply to them. But I just have this section in as a fallback to a fallback. How do we administer the non-qualified assets? What happens when they attain the age and they're in complete control? This is a standby special needs trust. Again, we're only providing for Jeff in a special needs trust in this document. What about everybody else? What if Dan becomes incapacitated? What if he could get on government benefits, but because of the receipt of the money, he can't? This allows us to keep it protected and get Dan and Reese qualified for benefits. The money would go into a supplemental needs trust. So you're going to see all the same language that you saw, not verbatim, but very similar to what you saw in Jeff's section, allowing us to supplement the benefits, not supplant them. Very similar to the language that we saw earlier in the other paragraph for Jeff. Again, the trustee consult with other people. We can pay taxes. And how do we do it if there's any retirement accounts? How do we stretch it out over the person's life expectancy? A lot of redundancy here. Again, not being forced to satisfy a support obligation. We want him to qualify if he possibly can or she possibly can. And we can review other benefits to determine if it's in the best interest of the person and what we won't distribute for. Very, very, very similar. And then if the person dies, we're going to pass it on to their children per stirpe. So again, just having that fallback provision there. Ultimate distribution, certainly out of the gate, it's going to provide for lineal descendants. Who would have died if we had died intestate without a will or a trust? That will preserve not triggering the 2% transfer tax. So we want to make sure that we do that as well. Now we get into the appointment of the trustees. Essentially, this section is saying at a minimum, we have to have one trustee, maximum of 3. Really, that's just semantics. We have it built in so that it's going to be you and your spouse, and then you'll have a child. If you're not married, single, widow, or widowed, it would be you and then another person like a child. The bottom line here is if you're the grantor and trustee, you can't have direct access to it, right? So we're going to need another person. If you're the child and you're receiving it, if you could just reach in and take it, so can a creditor. So this is where we're going to potentially have a second trustee acting with you simply for the sake of preserving the asset protection. We don't going to require anything crazy for the trustees. They don't have to post bonds. We're typically providing for family members. If there is a corporation that's acting for you, potentially they will have one anyway, but we're not requiring it in this situation. This is where you're essentially saying, when can people be a co-trustee? When can they help manage the assets? When can they help make decisions for it, right? And that is at 25 years of age. So that part is going to be similar, I imagine, across all of them. That is our default. And then when we appoint trustees, of course, it's Mark and Sarah to start. Then if we're in need of additional, it is Dan and Reese in the order named. We typically are telling you to pick one and then the other one because a lot of institutions are not allowing more than one person to be it currently. So that is our advice. Of course, for the spousal only retirement trust, it will be the spouse. And then for the separate shared trust beneficiaries, we named different people. And of course, in this case, we did Dan for Reese and for Jeff, and then Reese for Dan, just to provide of who the backups would be. Here's where we're seeing the supplemental needs trust for Jeff is going to be Dan and then Reese. And then as we go down, of course, we're just going to be naming the regular trustees for the standby special needs trust and the understated age trust. Foreign trustees, somebody who is not a U.S. citizen, certainly take it into consideration and understand the tax consequences. In 20 years, I have not had this come up, but we leave it in here just in case so that we know it's a decision that we need to make. A trustee is allowed to resign if he or she does not want to act. We could not force somebody to do so. All right. Of course, the grantors can remove trustees at any time. The beneficiaries have the right to do so as long as they agree. Now, notice in here that Dan can remove at 25, but Reese cannot until he is 65. This is where we're treating them differently. Jeff will not have the right to remove ever. The trust protector also has the right to remove in case somebody loses capacity. But you'll see later who the trust protector and the trustees are limited to appointing. Of course, this is where we also are mentioning the 25 and 65 year age. Your case probably will say 25 if you were treating everyone the same. If you don't trust anyone, it was probably going to say 65. Trustee vacancies talks about if we're going to appoint someone, it has to be a family member, a CPA, an attorney, a professional, someone who does it for a living, cannot be the girlfriend or the boyfriend. And if you are picking a CPA or an attorney, they cannot be related by blood. Okay. So just some restrictions to kind of narrow who people can appoint. What happens if we have a vacancy? Again, we'll see the same restrictions. What if we have a vacancy in the understated age trust? We can appoint one as well, subject to the provisions above, and a trustee can be compensated. Generally, family members don't take compensation. It would be considered income. You would have to claim it on your taxes, but we're required to put it in here. So, we do so. If the trust is written in such a way that I can take direct access to it and it requires another person to sign off, then I don't have the authority to singly sign off. We need the other person to as well in order to preserve the asset protection. Grantor can act as trustee, and the trustee will not do anything that's in direct violation of the terms. Trust protector. This is where we talk about the law firm. You will see that I am appointed here, and if not me, anyone affiliated with the law firm or any successors or assigns. I do have a buy-sell agreement in place. We do have it funded by insurance, so that my wife would be able to get some payment for the business and the firm would continue on. We are very fortunate and blessed that we have close to 30 team members, and they will also want to continue their jobs and their livelihood. So the trust protector could then be the firm or whoever takes over for the firm, even if they happen to change the name. You can always change who it is. You're not stuck with us. You're not stuck with them. We just want somebody to be named to be able to protect your family in case of a disability. Trust protector can resign. You can remove the trust protector. The beneficiaries can remove the trust protector. And if there's a successor trust protector that has to be named, what are the limitations? And any successor trust protectors would not be held liable for anything that we did or didn't do. I can tell you that is very rare. I could probably name on one hand how many times we've had to act as trust protector. And to date, I don't even believe we've charged a penny for any of those services. One family asked me to arbitrate or to kind of sit and help mediate a discussion between two brothers. I'll use the word discussion. And I said, you want me to sit for 8 hours? I have to charge you my hourly rate. But they were only fighting over $500, so they were able to come to an agreement. But other than that, we've kind of just answered questions and taken care of it and appointed people and not have charged anything to date. If there's a vacancy, who can be appointed? Again, we're looking at CPAs, attorneys not related by blood. And of course, Reese and Jeff have the right. Reese and Dan. Dan has the right at 25. Reese has the right at 65. I apologize. What are the powers of the trust protector? What are the things that the trust protector can do? They're listed here. As I said, it's an administrative provision in case someone becomes incapacitated, loses the ability to do it for themselves. It's just giving us the ability to do it on their behalf. What powers do you have? What powers do your kids or family members have as trustees or whoever you're naming? Anything and everything that they need to do. Right? We're not restricting them. We need them to be able to do everything they need to do. But of course, I can't just say that. I have to specifically provide for it. Of course, their signature can authorize on behalf of the trust. And what is the general authority? We list it, and it goes on and on. This is similar to your power of attorney, similar to the provisions that you saw in the will and the revocable trust. And of course, we're just going through some language here in regards to taxes. If by some reason the trustee needed to purchase life insurance, they would have the authority to do so. Very rare that we've ever needed it, but I have seen cases that it wasn't in the document and it was a good idea. The trustee could not do it, so we want to make sure that we absolutely provide for it. If the trust has a de minimis amount of money, it can be collapsed. We certainly don't want to keep something, particularly for the kids, if there's not enough money to justify it. So we have the ability to collapse it. And we're not going to do anything that's going to violate our fiduciary duties. So that's the restriction paragraph. And then we're into retirement accounts. So you're essentially seeing this for what, the third or fourth time? Again, all out of the Secure Act, right out of the Internal Revenue Code. making sure that we get the best possible tax consequences under the new act, defining eligible designated beneficiaries, discussing retirement accounts, telling us that we won't violate any of the acts specifically, and we'll stay within it, particularly with retirement accounts. You can disclaim. We did talk about that earlier, and that's the paragraph that talks about it. If we make distributions, if it's allowed to be a conduit trust, we can use that. If it can be an accumulation trust, such as a special needs trust, we can keep it in. We did discuss that earlier as well. I'm kind of flying through this because we've already seen it now for the third or fourth time. Still talking about Secure Act, talking about what we need to do, talking about required minimum distributions. For most people, you are going to be forced to take it out of the trust, not for special needs trusts. And then definitions. We define the most commonly litigated words, headings, and phrases. Why? Because I don't want your kids or other people to fight over what you intended. No. We're intending the meaning of the word to mean the meaning of the word, right? Lawsuits happen because of disagreements about what someone said to someone or didn't say to someone, or someone thought they said or didn't say. This is saying, I want the word to mean the word. Don't bring in extemporaneous conversations about this and that. No. I mean what I mean. If I have a stepchild, then I will say I want to provide for that stepchild. If I have a, adopted child, they're my child. So I don't have to define them. Child is natural born or adopted. And the rest of these are really just taken out of case law that has happened around the country in cases that could have been avoided that weren't, simply because people didn't define the words. So we spend pages and pages defining words so that people can't fight over what you intended. If we intend it, we're going to put it in, okay? Very inconsequential to you at the moment, because that isn't the case. We would have provided for something specifically if we wanted to. And then, of course, the notary provisions to follow. So just a few thoughts in general. This is your asset protection trust. It's going to protect the assets during life and then after death. We'll give your kids the ability after death to make a decision, particularly if you're allowing them to control it currently when you pass away. They'll make the right decision for them. I can tell you, in 20 years, I've never had anyone not leave it in the trust. I have people calling saying they want to, but I always say, no problem. You give me 30 minutes to an hour. And if at the end of the 30 minutes in the hour, you still feel the same way, you will have the money by tomorrow at noon. Nobody has taken it. When they realize that they can't lose it to a divorce, a nursing home, a car accident, and only they can control it, it makes complete sense. Yes, the trust says irrevocable. Yes, but that doesn't mean you can't change it. It only means you can't give it directly back to whom? Yourself, right? Yes, if we needed to get money out of the trust, we can get it back to you tax-free. We will use Larry, Moe, and Curly. Now, in this instance, we used Larry, at least in our examples in the blueprint, because we trusted him the most. That lifetime section does provide for other people. Doesn't mean you have to give it to them. It means if we need it, we can. In the income section, we recommend that you not be an income or a principal beneficiary. That way the nursing home can't get any of it. However, if you are relying on income from a rental property, we would like to limit the amount that you can get to a certain amount of money per month. We discussed it in the blueprint. We talked about it earlier. Please write your questions down, so when you do the one-to-one attorney review meeting, you can be on point and make sure that you don't forget anything, and also make sure that you can stay on track so that the meeting can be efficient, and so that we don't waste a lot of time digging through and trying to find things. Try to get organized before that call. Biggest thing I want you looking for is spelling mistakes, or if there was a misinterpretation of who you were providing it to and when and where. Remember, if you have people you want to provide for that are not lineal descendants, we don't want to do that now. We can do that later after 6 to 8 months. You do exercise or have a power of appointment that will allow you to make that change, which we pointed out in the document. That is the stuff that you need to focus on. Yes, there is a lot of paper. I understand that. We have a contingency for the contingency for the contingency. My job is to protect you and your family, to make sure that we provide the best possible tax consequences, the best possible asset protection. understanding that things can change. So there has to be flexibility. That's why the document is long. The parts that you really need to pay attention to are who are the grantors and the trustees? Where does the money go after death? Who gets it? When do they get it? How do they get it? And who are the trustees for those separate shares? The retirement stuff is really not all that important. The administrative provisions are not important. The definitions are not important. All those sections, yeah, you can breeze through, but those aren't really where the meat is. The trust protector section, you should definitely read. If you want to name someone else other than us, we have no problem with that. We just need it to be a professional so that it meets the requirements of the document. The advantage of having us is A, we're not charging unless, as I said earlier, there's some crazy thing that we have to do. But B, we know the documents and we understand them. So that's where we always kind of default to it being us. Doesn't give us any control or any rights that we wouldn't otherwise have. We just are able to assist your family, which we couldn't do if we weren't named. So that's all we're trying to do in that section. Hopefully this video was helpful. I realized that I went on and on and on, but again, the old meetings would be a total of, 40 minutes. This video alone was more than that. And that's because I wanted to really dive into paragraphs and explain them. Please write down your questions. We look forward to seeing you at the attorney review meeting. And our attorney will be able to answer your questions. And please have any comments as far as changes or spellings and those kind of things ready to roll, as well as your questions so we can be efficient. Thank you very much. After you sign the documents, we will be doing a funding meeting, which is basically a funding video describing what will occur in funding and what a funding chart is, what the instructions will look like, and how we're going to take care of that process moving forward. I look forward to seeing everyone complete and sign their docs and get everything in place so that we can get these assets protected. We can protect your family today and tomorrow. And that is what we're looking forward to. We look forward to seeing you at the monthly Red Wagon Club member events. On average, we're doing one a month, and we certainly try to provide a lot of value. If anything changes in the law, we will notify you. You can come in whenever you want to ask questions or make changes, and we can get them done in an efficient manner, as we have people dedicated to the Red Wagon Club members to provide great service. So we look forward to seeing everyone. I hope this video was helpful, and we'll look forward to seeing you all real soon. Thanks again. Until later, we'll see you real soon.